You have requested a hearing about your unemployment insurance benefits, or have received a notice to appear at a hearing that was requested by one of your former employees. These videos contain important information to help you prepare for the hearing. They will cover 3 stages: what you need to know before the hearing, during the hearing, and after the hearing. The information provided in these videos will serve as a guide to help you through every step of the hearing process. The Unemployment Insurance Appeal Board, or UIAB, was established by State of New York law to hear and decide disputes over unemployment insurance benefits for claimants and for employers' liability for contributions to the unemployment insurance system. The UIAB has 2 levels, the hearing level and the board level. At the hearing level, claimants or employers have the right to challenge Department of Labor determinations in front of an administrative law judge. At the board level, the party who lost after the administrative law judge hearing can file an appeal, and the record of that hearing will be reviewed. Before the hearing. After you request a hearing, you will receive a hearing notice. This will be about 10 days before your hearing is scheduled to take place. You should review all information on the front and back sides of each page carefully. The notice will tell you the time and place of the hearing, who has been invited to appear at the hearing, the issues that will be decided, any special instructions to produce documents or witnesses. Hearings are currently held by telephone. You must be ready to answer the telephone at the time indicated on the notice. If you were the one who asked for the hearing and you do not answer the telephone when the judge calls, the hearing will be closed. If the other party asked for the hearing and you do not answer the judge's telephone call, the hearing will go ahead without you. The administrative law judge is impartial, meaning he or she will not be on the side of any of the parties at the hearing, the claimant, the employer, or the Department of Labor. The judge will hear the evidence of all sides and make a decision based on the evidence. The judge will give everyone a chance to explain what happened in the case. It is common for parties to represent themselves at the hearing without an attorney. However, if you want your attorney or other representative to be with you, tell that person about the hearing and give their name, address, and telephone number to the hearing office so they can be contacted for the hearing. If you don't have a representative or attorney, but you want one to help you at the hearing, you should contact one right away, so you have enough time to meet and prepare your case before the hearing date. A list of attorneys and representatives was sent to you when you asked for the hearing. There is a list of free attorneys and a list of attorneys and other representatives who may represent you for a fee. You may also find those lists on the UI Appeal Board's website. We cannot assign you an attorney. You must contact an attorney yourself and arrange for the attorney or representative to represent you at your hearing. If you cannot read, speak, or understand English, we will have an interpreter for you at the hearing. The interpreter will be on the telephone with the judge when the judge calls you, so you can understand everything that is said at your hearing, and everyone can understand you. Even if you filed your claim in English, you can still have an interpreter at the hearing to assist you. Call the phone number listed on the first page of the hearing notice as soon as possible to request an interpreter. If you are hearing impaired, let the hearing office know as soon as possible after getting the hearing notice. We will get in touch with you to arrange a way for you to take full part in your hearing. A copy of your file will be sent to you. This file will have documents in it that the judge may use during the hearing. It is important you review your file before your hearing and have it with you for the hearing. The judge will refer to the page numbers on the bottom of the document in the packet. It is important that you keep the copy of the file in the same order that it was in when you received it, so that you can quickly turn to the pages the judge is looking at. If you do not receive the file, call the number on the notice for assistance. At the hearing, the judge will ask you questions. The judge will let you testify and tell your side of the story. The judge will also hear testimony from any witnesses you have. If you have a witness, tell them well before the hearing date that you need them to be ready to be called. Keep in mind, testimony from people who saw or heard the key events in your case is much more important. than testimony from people who only know what other people told them. Also, testimony of a witness who saw what happened counts much more than a written statement. If you need a document or a witness that is outside of your control, you may ask for a subpoena. A subpoena is an order from the judge directing the witness or document to be produced. You may ask for the subpoena at the hearing. You should also gather any other documents that you believe help support your case. No later than 3 days before the hearing, send copies of these documents to the hearing office and to the other parties that are on the notice of hearing. Write down any questions you want to ask your witnesses or other side's witnesses. This will help keep you on track and help you to remember to ask important questions. Make a list of important dates or events related to your case. That list will help you present the facts you think the judge should hear to decide your case. A review of the Unemployment Insurance Bench Manual, New York State unemployment insurance laws, and prior appeal board cases can possibly help you in preparing for your hearing. You can find these resources at the UIAB's website. If you are unable to attend your hearing, you may request an adjournment. As soon as you realize you need an adjournment, fax or call the hearing office. The numbers can be found on the front of the hearing notice. Make sure you explain why you need the delay. The judge will decide whether your request can be granted. If the judge denies your request for an adjournment, or if you are suddenly unable to attend a hearing, and you get a decision from the judge that is against you, you may still ask to have your case reopened. The request should be made in writing to the hearing office as soon as you receive your decision. When you apply to reopen your case, another hearing will be scheduled. At the beginning of that hearing, the judge will ask you first why you did not come to the earlier hearing. Prior to the second hearing, send in any papers that show why you did not come. If the judge decides you had a good reason for not attending the earlier hearing, the judge will reopen the case and give you an opportunity to testify and present evidence on all the issues from the earlier hearing. If you follow these basic steps, you will be well prepared to present your case at the hearing. Day of the hearing. Be prepared for the judge's telephone call at the time indicated on the notice. The hearing may last 60 minutes or longer. It will take as long as is needed for the judge to make a fair decision. It is important to pay close attention throughout the hearing, so plan on taking the call in a quiet place where you won't be interrupted. Have your witnesses and documents ready. Have the telephone numbers for your witnesses if they are not with you. Have a notepad because it will help you to take notes during the hearing so you can present your case and ask the other party the right questions. Who will be there? The claimant, the employer, and the Department of Labor all have a right to attend the hearing. What will happen at the hearing? When the judge calls you for the hearing, if you can't go forward for any reason, let the judge know as soon as they ask you if you are ready. The judge will make an opening statement explaining the rules of the hearing. When the judge finishes, he or she will ask you if you have any questions. Let the judge know if you do not understand something that was said or if you have other questions. The judge will tell you who will testify first and what the order of witnesses will be. The judge will also ask witnesses who are with you to wait in a separate room, or if they are at a different location, to disconnect from the call so their testimony is not influenced by the testimony of other witnesses. All testimony is taken under oath or affirmation. Listen carefully to all the questions and answers from everyone who testifies. After the judge questions someone, you'll have the opportunity to question that person too. If you have difficulty asking a witness a question, the judge can help you form the question you are trying to ask. All questions have to be connected to the issues in the case. The judge will let a party know if their testimony or questions are not related to the issues in the case. You also can object to any question that you don't think is related to the case. The judge will decide the case only on the testimony at the hearing and any other evidence that the judge makes part of the record at the hearing. Documents from the file are only considered if the judge makes the document part of the record. Ask the judge to make a document part of the hearing record if you think it helps your case. You will have a chance to tell the judge why you want the document made part of the record. You can also object to any document that the other party wants to make part of the record. After all witnesses have been questioned and all evidence has been taken into the record, the judge will ask each party if they have anything else to say or to present. This is your chance to summarize your case and explain why you think the judge should decide the case in your favor based on the evidence. After the hearing, the judge will not tell you the decision at the hearing. When the hearing is over, you should receive the judge's decision in the mail within a week. If you don't receive a decision, call the number on your notice. After receiving the judge's decision, read it carefully. The decision will have an opening section stating the issues. It will also have finding of fact, which is where the judge writes about the key events in the case that the judge found to be true. There is also an opinion, which is where the judge writes about how the case must be decided, based on the facts and why the judge believed one side or the other if there was a disagreement. Finally, there is a decision part at the bottom, which tells you the result on each issue and whether the claimant is allowed benefits. If you disagree with the decision, you have a right to appeal to the appeal board. You must appeal within 20 days of the date on the decision. Directions on how to file an appeal are found on the back of the decision. Make sure you read those directions carefully and follow them. When you appeal, you may request a copy of the transcript of the hearing so you can write to the appeal board and tell them what you disagree about. For more information, visit our website